want to stay right there for that? If you're going to be up here for the things that follow, you can get situated up there. It's really up to you. They made it sound like it would be today, though. Just they couldn't say, hey, it's the next 10 minutes.
They're gonna be here today.
Okay. Who's the other Cobb person?
Reynolds.
Reynolds? Okay. All right. So Reynolds and McClone we're holding on. All right. Oh, let me go. I have my Mcwell paperwork. I'll be right back. It's true.
What's that?
You want to burn, right?
It's gonna be 2 years. That's a recommendation. I'm asking for probation with first offender. Yeah, for sure. And Judge, may I approach real quick?
Sure. Thanks. Okay, let's get back on the record in Mr. Mcwell's case. It's 25 SC 004117. And last week, Mr. Mcwell, you entered a plea. So I've accepted your guilty plea. I learned that this is a situation kind of near Greenbrier from June of last year. There was some issue with you and your car. I think it was actually Ms. Brown and her car plus the Watkinses, and you ultimately got out and fired some shots near a Bank of America. Fortunately, no one was hit, but I think a couple of vehicles were hit. Those are the trespass counts that I think you damaged some vehicles. We were holding off on sentencing. You have 3 prior arrests, including this one, no felony convictions. So, Ms. Smith, why don't you start for the state? Let me know what the state's recommendation is, and if you've got any victim impact statement from the Watkinses. I don't see anyone online, so, but you may have important info to share.
Yes, Judge, starting with the recommendation in this case, for counts 1 through 3, the state is recommending 5 years to serve 2 with the balance probated. For count 4, possession of firearm during, we're asking for 5 years to run consecutive. And then for counts 5 to 6, we're recommending 12 months to serve. For counts 1 through 3 and 5 and 6 to run concurrent, and of course for count 4 to run consecutive. Special conditions of probation, we're asking for the defendant to complete an anger management course, to have no contact with the victims, and to be gainfully employed. I did have an opportunity to speak with the victims who were shot at that were in the car, and also the victims of the the people whose cars were damaged. So the people of the ag assault charges and the people of the criminal trespass charges. Starting with the Watkins, they did not want to be on Zoom or be in person. However, they did tell me that this was a serious crime and they want the defendant to be held accountable because there was a child in the car. They just asked for updates after we got out of the court, but they did not want to be here. And as far as Ms. Wilcox, she is one of the people whose car was shot. She was inside of the car when it happened. I had a conversation with her and she said that this has changed her life drastically. She still has a bullet hole in her car that she has not been able to get fixed. Her window was also busted by one of the bullets. She was able to get that fixed, but just not the bullet that's still in the car. She said that because she's not able to afford it, she didn't go to work for a while because she was scared based off of what happened to her. And she's just been trying to navigate life since it happened. She's been kind of taking it hard. I spoke with the other person whose car was shot. They were not in the car at the time. Miss Gordon, she said that she did not want to basically be a part of this process. She would like restitution. However, I have not gotten any receipts or documentation from her. But regarding the victims in this case, those are the statements that they've asked me to relay to the court.
Okay, got it. So 10 served 2, balance probated with the conditions that you mentioned.
Yes, Judge.
All right. Mr. Fortis.
Thank you, Judge. We're seeking 10 years probation. We're also seeking first offender. I know that that's discretionary with the court, but when we did do the plea colloquy, he is first offender eligible, and you indicated you would just take that under advisement at sentencing. So I just wanted to make sure that the record was clear what we were seeking. I'm going to give you a little background. I'm going to give you why I think we're seeking this. I'm going to call his mom as a brief witness. But outside of that, Mr. Mcwell is 30 years of age. He's lived in Georgia his entire life. He has very strong ties in the community. He graduated high school. He maintains stable employment with Amazon. He's a law-abiding citizen outside of this. This was just kind of a one-off. We'll get to that in a minute. The incident kind of arose out of an escalating situation, not really for him, but for the driver of the car that he happened to be in. And I believe, the alleged victims in this case that were kind of jawing back and forth regarding some erratic driving. And depending on who you want to believe, whether it was the erratic driving by the vehicle that my client was in or the erratic driving by the other individuals in the other car. And that continued on, and we'll get to that in a minute. The evidence will demonstrate that really has not been conveyed to the court, in my estimation, correctly, and that the alleged victim actually significantly contributed to and escalated the confrontation. According to the police report, the alleged victim armed herself with a brick and then challenged the parties to a fight. This was in the police report. This is also statement witnesses that were in the police report. So the alleged victim in the case gets out of the car, arms herself with a brick, threatens not only my client, but threatens the driver. As I indicated, there was an independent witness that corroborated that the alleged victim threw the brick through the rear window of the vehicle, causing extensive damage and contradicting portions of the alleged victim's statement to law enforcement. So what ended up happening is that when law enforcement arrived onto the scene and interviewed the alleged victim in the case, the alleged victim indicated that there was a verbal altercation. That's all it was. What escalated the situation is when the alleged victim gets out of the car, arms herself with a brick, basically says, "Do you want to fight?" And then proceeded to throw the brick through the window. So when the police arrived on the scene, she negated that she threw the brick through the window. And obviously, and I've shown pictures to the state regarding the brick that did go through the window. And not only that, there were independent witnesses that were there that were there on scene and stated that she threw the brick through the window. So in essence, the alleged victim in this case was not truthful to the police. So it caused them to question a lot of what she asserts happened in this case based on her ability when they arrived on the scene to not be truthful about what her actions were. Prior to the big brick being thrown, the encounter was verbal. I mean, that's all it was. And then she escalated it. And one would say, if she's so concerned that there was a child in the car, then which my client did not know that there was a child in the car, regardless, why would you escalate a situation and arm yourself and threaten somebody? And that's exactly what happened. He reasonably perceived, my client did, the situation as dangerous once the alleged victim armed herself, threatened violence, and then acted on that violence by shattering the back window of the vehicle that he was in. While he acknowledges his reaction may have been excessive and he accepts responsibility for the conduct, and that's why we're here today, the facts clearly show that this was just not a one-sided incident where Mr. Mcwell gets out of the car based on a verbal dispute and starts haphazardly firing his weapon. No individual was struck. There's no physical injuries by the discharging of the firearm. Mr. Mcwell, as I stated earlier, was unaware that there was a child in the other vehicle at the time of the incident. And I think that if I want to elaborate on that, as Your Honor will recall, I think at calendar call when I had indicated that we were contemplating filing an immunity motion at that time. And I spoke with Mr. Mcwell at length about that because I think we had a meritorious argument. And I think that not only that we had the alleged victim in this case just not being truthful. However, we talked about was the force, was it reasonable in nature, number one. And number two is I think that Mr. Mcwell felt, very bad about the fact when he learned that there was a child in the car and not what happened, but more or less what could have happened. So he decided to forego that route and move forward with accepting responsibility before that court. And that's what brings us here today.
So I'm curious, I'm looking at the original booking information just had citations, but there's a much more thorough affidavit from, seeing if it's a detective, some officer, who clearly had done some work on the case.
Yes.
It references one of the Watkinses, with a brick. That person says, I didn't throw it. Mr. Mcwell turns himself in. You had mentioned that last week. He's like, hey, you need me. I'm coming in to talk. He said that the rear windshield had been broken by the brick, but then the officer says there was no damage to it, looking at an uploaded video, and Mr. Mcwell could not confirm ever seeing a brick in the vehicle. So we're not trying the case right now, but I'm just trying to work through. It's clearly more complicated than it initially sounded as I look at this affidavit, where we've got one of the victims admitting, I got out with a brick in my hand. She says she didn't throw it. Someone holding a brick is different from someone throwing a brick. And so I'm just curious.
Can I approach?
You sure can.
This was received by my client, and this is his car.
Okay, I mean, that's a car with a hole in a window. I don't know if it's this car, but okay.
Well, and I can also tell you that there were statements that were gathered independent on the scene, and the independent witnesses corroborated that the alleged victim in this case threw the brick through the back window.
Okay.
Okay, so regardless of what anybody, what the police report may say regarding that, there is corroborated evidence through independent witnesses who were on the scene that saw her throw the brick through the window.
Okay.
Okay. And as the court just alluded to, the court should consider that when Mr. Mcwell was contacted by law enforcement, he voluntarily went down there immediately to give a statement, knowing, number one, that he may be arrested, but certainly he wanted to let the officers know what his side of the story, was. And when he got there and gave his side of the story, he was subsequently arrested. He was subsequently given a bond thereafter, not at first appearance hearing. We did have a bond hearing before Your Honor. And during that bond hearing, Your Honor put Mr. Mcwell on an ankle monitor. I would say that he was on roughly about 6 months on that ankle monitor without incident. And then it was removed. During the pendency of this case, he completed 50 hours of community service. He did a firearm and gun safety course. And more importantly, all bond conditions from this court, as you stated from up there to my client, and talked about the seriousness of the event and that we could have been here for something much worse. You basically advised my client of what those conditions were going to be, including the ankle monitor, and he complied with each and every one of those conditions that the court put on him. While he was out on bond without incident, it demonstrates that I don't believe he's a danger to the community and that he is successful. He is capable of being successful in any type of rehabilitation conditions. The state wants him to do some sort of anger violence courses. We have no problems with that. I think that is warranted under the conditions. He does not know these alleged victims whatsoever. He's had absolutely no contact with them either before this incident nor during nor subsequent to the incident. There are mitigating circumstances to the facts. It's not just that there was a verbal altercation and Mr. Mcwell jumped out of the car and started firing. I think that one could say that he felt threatened at that point, just whether the response was reasonable or not, and what that reasonableness, is. A probationary sentence under the first offender it adequately punishes him, keeps the court with the tabs on Mr. Mcwell. I'm sure the court's heard all that before, and being accountable for whatever conditions, the court may put on him while protecting the community and preserving making him being a productive member of society as he has been by working and helping his family and supporting his family. He has a lack of criminal history. There's no felonies at 30, 31 years of age. He's demonstrated his ability to be compliant on bond, which makes, in my opinion, his ability to be compliant on probation. He's here to accept responsibility, not only through denial of filing an immunity motion, but certainly trial. And I believe that he's got substantial mitigation in this case, not only what he's done on his own, but certainly the facts and circumstances. And I don't need to tell the court that when the police come to the scene and you're not truthful on what your actions were, it leads one to believe or to think, what was really said or what was really done based on the purview that if you were to accept that from the alleged victims. So in this particular instance, Judge, what I'm asking for and what I think is warranted in this case is I think that the 10 years on probation with first offender, with the anger management component, if the court would like any additional community service, Mr. Mcwell would be happy to complete any additional community service as well, or any of the conditions that the court may deem appropriate. He is holding himself accountable for what happened. I just think that incarceration is intended for those who cannot be rehabilitated or who pose an ongoing danger in the community. I just don't think that his history nor his conduct nor the person that I've gotten to know demonstrates that. And if we think about what is really going to be achieved by incarceration, I think the messaging has been sent, number one. He's taken it extremely serious, number two. And then he gets out, however long that they hold him, and now he's without a job, without a home, without a car. And I mean, yes, those are conditions and circumstances of conduct, but the reality of it is that does this conduct, and based on all the facts and circumstances, does that really warrant incarceration in this case? And I think that and I keep bringing up that based on the veracity, when the police came onto the scene, just calls into question, it raises a lot more questions than answers from the alleged victim in this case. I think a probationary sentence still serves the interest of justice. And I think that this young man will benefit from that, will learn from that, and will continue to grow from that. And I think that that's what the expectation is from this court. And I think it is the expectation from any court is that what does it look like moving forward? And I think that the fact that there has been no hiccups along the way, that I don't anticipate there being any hiccups during the course and pendency of any probationary period. And I think it's warranted in this case. I'd like to just call his mom briefly,
Okay.
if that's okay.
Sure. And she doesn't need to testify. You can just have her stand wherever deputy wants her to stand, and she can share what you want her to share.
Okay.
Good morning.
Good morning.
You don't have to be sworn in. You just need to tell me your name.
My name is Wanchella Mcwell.
Okay.
Good morning, Ms. Mcwell.
Good morning. I'm Sebastian Mcwell's mom.
Okay.
Okay. And just, has he lived in Georgia his whole life?
Yes, sir.
Okay.
Where was he born?
He was born here in Atlanta, Georgia.
Okay. Grady baby?
No, he's Emory.
Emory baby,
Yes.
okay.
Tell the court a little bit about your son. What kind of
Okay,
son is he?
for starters, Sebastian is not a confrontational guy. I never had problems out of him. Like the last time he finished high school, went to community college for culinary art. He been on a good path. Before this incident, he was working for this tech company. He was about to convert over permanent. This incident happened. He lost his job. He had just bought his first car. So
The
his
car that was in this situation or a different car?
this car right here.
Okay.
He bought it for himself for his birthday.
Okay, who is Ms. Brown to him?
At the time, his girlfriend.
Okay, so she was driving his car.
Yes, sir.
Got it.
And ever since the incident happened, Your Honor, Sebastian, I think he's depressed about it because after the last time he was here, y'all stated that it was a child in the car. And that bothers him because he loves kids. And right now, like he's a helper with Amazon Flex. He's doing well. But since this incident happened, it's like he's kind of iffy by, his confidence in the working world right now. And he's not confrontation. I don't have no problem out of Sebastian. And since they put the monitor on him and everything, he's done everything the court asked him to do. No hiccups. So I just feel like he need a second chance because he's not a bad person.
Does he stay with you or does he have his own
He
place?
stays with me, and I got a disabled sister.
Okay,
I work at the job that he was finna get hired on.
Yeah.
I got hired permanent.
okay. Well, congratulations.
Thank you. And he helped me with my sister who's
Okay.
disabled.
Sure.
Because I work a lot of hours. But like her therapy, doctor's appointment, when I can't make it, Sebastian, anybody take Sebastian will take her for me.
Okay, but he has a place to stay then in the form of the house that you and your sister occupy.
It's myself, it's my home.
Your home and your sister is
She
there.
got her own home.
Okay,
So, but when her doctor's appointment and her therapy come, if I can't make it, Sebastian will go for me.
got it. So your sister lives on her own,
Yes,
but
sir.
you help care for her as does your son, and your son lives with you.
Yes, sir.
Got it. Okay. Well, I appreciate you being here. Thank you.
Thank you so much.
You're welcome.
Judge, I think that's all I have for the court.
Okay.
At this point.
Mr. Mcwell, anything you want to add?
If it was a child involved, I apologize because that really did like mess with me, especially when I was sitting out. And when I got out and I was on the ankle monitor, it was on me heavy. But now, like, I'm trying to get around the curve, find employment, get over this situation and just move on with my life.
Okay. All right. You can take a seat. You don't have to stay right there.
Thank you.
Ms. Smith, in the warrant that I'm going to say it's Detective Leonce, Leonce, completed her affidavit. She says that this car that now I know is Mr. Mcwell's car, but that Ms. Brown was driving, was impounded for processing. I'm just curious if you have any information from the police reports. If there was a hole in the back window, it would have been there when they processed it. This seems to be a point of contention. I've seen a picture and you've seen a picture. There's a picture of a window with a hole in it. I can't tell if that's a Kia or not. I don't know that it's Mr. Mcwell's car. I'm not doubting Mr. Fortis, but anyone could have given him that picture and said, hey, that's the car. I'm curious what your file shows about what law enforcement learned about the state of the vehicle.
Yes, Judge. It was kind of something that was mentioned but never followed up on, even when the car was impounded. They didn't say much about if there was a brick found in the car or some type of hole that was in the car. When I spoke with the victim, Ms. Watkins, she did say that she never threw a brick. So that was something that she's still saying. But as far as what happened after the car was placed in the property of the agency, they didn't follow up regarding if there was a hole in the car.
Okay. If they photographed the car, those photos didn't get to you and then ultimately to Mr. Fortis.
That's correct.
Okay.
And Judge, if I can just say this, that there, in the police report, there's a narrative by Officer Taylor Washington. And in that narrative, he states this is reading from the report, multiple witnesses, including Lanice Gordon stated that during the verbal dispute between Asia Watkins and the suspects, Asia did throw a brick into the suspect's back windshield, first while trying to physically fight, and then the male suspect fired his weapon at Miss Watkins.
Okay.
So that's in the narrative.
Got it. And did you say, Ms. Smith, that one of the two, I'm not remembering the names of the
Of the
two
victims.
car owners,
Mhm.
was one of them Ms. Gordon?
Yes, it was.
Okay, so that's the same person.
I'm assuming yes.
Okay, got it. All right. Well, Mr. Mcwell, I've already accepted your plea, so now we're just sorting out what ought to happen next. I see both sides of this. I don't understand how things spun up this much, and I'm fussing at Ms. Watkins as much as I'm fussing at you and Ms. Brown. But escalation is indeed what happened. People have attitudes when they're behind the wheel of a car, and it sounds like one of the Watkinses got out. That's escalation. And had a brick. That's escalation. Maybe threw the brick. That's escalation. And then someone brought a gun to a brick party and fired that gun. That's escalation, in a way that, in my mind, is a whole lot more dangerous than throwing the brick. And I don't condone the brick throwing. I think that Ms. Watkins maybe should be charged for damage to your car and to aggravated assault. That's an assault, throwing a brick at someone. There's this notion of proportionality. Do you respond to that? You being, I'm assuming, larger and stronger than Ms. Watkins, by shoving her to the ground or making sure she stops or calling the police? Or do you pull out a gun and fire it 3 or 4 times? And in my perspective, that was disproportionate, and it further escalated in a way that could have killed a kid, could have killed Ms. Gordon, who had nothing to do with anything. She's just sitting in her car. So I don't know where people were standing and if you were aiming at Ms. Watkins or aiming at her car, but you can see what happens when someone pulls the trigger of a gun. Bullets go straight. They don't go where you want them to go. And 2 of them went straight into Ms. Gordon's car. She's still driving with one of your bullets around, stuck in the side of her car. And none of that is okay. All of that is about as dangerous as can be. The one mitigating piece, and Mr. Fortas is doing his usual good job, is that it wasn't completely nonlinear by you. It's not that Ms. Watkins said, your Kia's ugly, and you jump out and you start shooting everyone. But that she did something that damaged your car. It's a crime, endangered you or Ms. Brown. A brick going through a window is also a dangerous situation. So I get it that it wasn't just Ms. Watkins is minding her own business and you didn't like the way she cut your girlfriend off or the words she said when you guys were fussing at each other. I don't have nearly as much information as Mr. Fortas. I'm not as confident as he is that an immunity motion would have ended with a ruling in your favor and thus the extinguishment of the case. But we're here now. You are taking responsibility. I appreciate that. Here's what I'm going to do, and hear out the sentence, and then know that you've still got your final plea right. So you can talk with Mr. Fortas and decide, you know what, I don't want to go to trial. I don't know what will happen then. So this is what I'm going to do. But let me ask Ms. Simpson a question. My recollection, and this was relatively new news to me and maybe to you, is that people can report to the PDC? Yeah. Okay. Mr. Mcwell, I am sentencing you on counts 1 through 3 to 5 years. Count 4 has to be 5 years. It will run consecutive to count 1. 5 and 6 will both be 1 month. And here's how those break down. 5 and 6 are 1 month to serve. 1 through 3 are probated, and 4 is probated. So it's a total of 10 years probation. It's actually 10 years to serve 1 month with a balance on probation. But the first special condition of your probation is that you complete 180 days. That's 6 months. That's half a year at a probation detention center. The second special condition is that you have no contact with any of the Watkinses. It sounds like you didn't know them at the time, strangers to
I
you.
don't know these folks.
Good. Keep it that way. You don't look them up. No family member looks them up. I don't know if you and Ms. Brown are still talking. She doesn't look them up. The Watkinses need to have no contact from anyone associated with you. I will sentence you as a first offender. Your lack of criminal history justifies that. And I appreciate your mother's information that you're just trying to keep moving in the right direction. But this isn't something that you get to walk away from quite that easily. So to recap, that's 6 months at the probation detention center, but that's something that you report to when they have an opening. So you don't need to go into custody today, should you choose to go forward with a sentence. But you will be notified by your probation officer, and it's usually a couple months wait, give or take. Hey, they've got an opening, and then you report to the detention center, you do your time, you're getting credit for your probation time while you're in there. And then you are back out and hopefully moving forward with work or school or whatever it is you're going to do. I don't see straight probation as an appropriate sentence, non-custodial sentence, I should say. A non-custodial sentence as commensurate with the seriousness of what happened here, even with the provocation. I'm not ignoring anything Mr. Ford has said. I hear it, and it would be a complicated trial. I don't know what the jury would do, and you may decide that's what you want to do. So, Ms. Smith, anything from the state about that sentence?
Nothing further.
Okay. Mr. Ford, any questions about the sentence before you and Mr. Mcwell discuss it?
Judge, just the 180 days, I think that he spent some days prior to getting a bond hearing.
He did.
Would that time, is the 180 days, is that negotiable based on either A, the time that he spent in jail before he made a bond, number one, and number two, because I know it sometimes varies from 90 to 120 to 180 days, depending on what the court orders.
Right.
And then number two, would the court take into consideration, the 6 months, not the entire 6 months, but to some of the time that he at least spent on the anchor monitor, without incident.
I've thought about all those things. I don't think the state's recommendation was off base in a vacuum. You've helped me understand that it was a more complicated situation and that there were aggravating factors on the Watkins side that helps put into context what Mr. Mcwell did. And so instead of 2 years, I think 6 months is appropriate. I'm aware of the 48 he did, and he gets credit for those against the month that I sentenced him for the 2 misdemeanors. So he's not going into custody today, but I do, you understand what my sentence is. So I guess the short answer is no, it's not negotiable. That's the sentence that I intend to impose, but Mr. Mcwell has his final plea rights. So you and he should talk about how this is structured, the fact that he'll get to turn himself in, not go into custody today, and that it's 6 months, not 2 years, and he can decide. I'll respect his choice and your advice to him on that. And if we need to try this, then the state needs to bring the Watkinses in, and we'll learn more about what really went down. And the chips will fall where they do.
Maybe we step outside just for a
Sure,
moment.
of course.
Judge, probably, this is Miss Tennessee, she's one of our municipal specialists.
Hi there.
Hi.
Welcome.
Thank you. She was initially going to be going to Judge Paul, but she also did. So, we're sending her to whoever's covering Judge Bartlett's case.
I think Judge Baxter is doing a fair amount of that. It'll be a series of senior judges that we bring in on an interim basis while we wait for the replacements, the successors to Barwick and Williams. Yeah. Okay. Well, that's a home.
Did you know that additional judicial seat has been,
So, I mean, the 21st judge, it's a complicated situation. The answer is that the legislature did pass the law that creates a 21st seat, but they didn't fund it. So we would need to find funding, and they don't hand that out. So for now, we're at 20 still. Yeah.
so they said yes, but we're not gonna add y'all.
Exactly, right. There was the feel-good moment of, okay, number 21. And then when it came to funding, they said, you know what, we're only gonna fund 3. And it was the original 3 that had been proposed, Gwinnett, the Middle Circuit, and one other. I don't remember, but not Fulton. So. They're talking, but we could do, if you've got something not particularly long, we could do that before I gotta get on this call.
Well, Frederick Avery is on the bath. That's the short one, but he's in the bathroom. How long would it take?
I don't know why she would know. Okay, and Reynolds isn't here yet. So you've got McGlone, but we're gonna do that at 1. Robinson, but that's gonna take a little while.
Okay.
Reynolds isn't here, so Avery would be quick. Well, I gotta wait here anyway. If we can squeeze in Avery, let's do that.
Okay.
Is that a negotiated revocation or you're not sure?
She wasn't initially. Just to drug or it's actually drug.
Yeah, I just need to, you know, do it.
Oh, let me double check.
Anyone that is, I don't know, the math of the month, that's like 2 months and. Yes. Which is just two. Oh. Just. Okay. And we'll just, I'll just put the language on it. Oh, look, I guess after them.
All right, let's get back on the record in State versus Mr. McWell. Mr. Fortis, you and Mr. McWell took an understandable break to discuss. Does he want to go forward or does he want to withdraw his plea?
Judge, he would like to go forward. I did discuss the court's recommendation, or the sentence rather, and he believes it to be in his best interest. I indicated with him that I was willing to try the case. I talked to him about the same things that we talked about before, which were, some of the pros and cons of the case and the outcomes of the case. I think that this is a good outcome. And the fact that the court's allowing him to enter his plea under the first offender, I would ask for two things. Number one, I would ask the court to consider restricting his record. I can send a proposed order so that when he gets done with this, because obviously he's going to lose his job, but in retrospect, without this on his record, I think that if the court were inclined to grant my request, that I think that he would be actually more employable to would-be employers for probably a better job than he has now. And I would ask the court to consider that. And I do believe that he's entitled to a behavioral incentive day.
Okay. Mr. McWell, I will certainly, and you should send a copy to Ms. Smith. The state rarely objects, but I will certainly enter an order that restricts access to this case. Because you're being sentenced as a first offender, it's not a conviction, which means as you're thinking about going back to school or getting a job, it's not the kind of thing that ought to pop up. An employer ought not to be able to see it. But that employer could right now. But if Mr. Fortis gets me those proposed documents, then I will certainly get those in place. As for the behavioral incentive date, I already thought about that. I think first offender is the right opportunity here. And I think you, Mr. McWell, will control how quickly probation would reach out to me to say, could we just close this case down? If you are on probation, the way you have been on bond, probation is very quickly going to get tired of having to supervise you because you're not presenting any challenges at all. And they can reach out, as they typically do when there's a longer term of probation, to say, can we terminate this early? But I'm not going to build in the bid. Given the fact that you're getting first offender, I think that benefit ought to carry with it the ability to monitor things a little bit longer, and certainly to give me the ability, if something doesn't go well while you're on probation, for there to be some pretty meaningful consequences. I hear your mom loud and clear, and basically your life story, that I'm hearing about your one worst moment. And I'm not painting a picture of Mr. McWell as this gun-toting, dangerous guy. Your worst moment just happened to be super dangerous, with a little kid in the car and a completely innocent bystander sitting in a car that got hit twice. That's what's yielding these consequences. It doesn't define you. And that's why I think first offender is appropriate. And that first offender is really not a risk for you. You're not someone who's going to have issues going forward. And so you'll be able to take full advantage of it. Anything else, Mr. Fortis?
No, Your Honor.
Okay. Ms. Simpson, we need to give Mr. McWell reporting instructions. Do you want to meet with him?
That'd be great.
Yeah, we'll get on the record.
His reporting date is May 7th at 10 a.m.
Okay, you live in Fulton County? Okay, so May 7th, and you'll be given a piece of paper, but that's about a week from now, 8 a.m. Don't miss that report date. And to be clear, that report date is you meeting your probation officer. You're going home that day. That's not going to the detention center. It's plugging in with probation so they can figure out, do a home visit, and connect with you, okay? All right, thank you.
Thank you, Judge. It's good to see you.
See you.